My name is Saul Simon. I'm a certified financial planner and fiduciary. And my intention for today's program is to have an impact that could just make a difference in your personal life. And what I'm talking about today is love. And what I'm talking about today is the disposition of assets and estate planning work. And people say, attorneys, accountants say that the process of estate planning is more of a financial process than it is a legal process. And why I say it's about love is because in the event of an untimely death, you want to be able to make things as easy and workable as possible for your significant other, your families and loved ones. So we don't know when we're going to pass on. And by not having a plan in place, some of the people we know and we think are so financially successful and have advisors with them that unfortunately they did not have a plan in place. And by the way, all my clients have advisors, hopefully competent men and women that have helped them with their legal, insurance, investment work. And I'm not looking to replace anybody. I'm really just looking to be an add-on, and I'll explain that in a moment. So what we want to look at is your assets. We want to look at your home, your investments, your savings, your retirement accounts. Now, the process of what we're about to discuss has to do with ownership and beneficiary arrangements. Assets pass on three ways. Assets pass on based on title or ownership. So if my wife and I own a house that's jointly held or a bank account, I die, it goes to my spouse. The second way assets pass on is through a contractual obligation, anything that names a beneficiary. I have a life insurance policy, I have an IRA, maybe a 401k or a SEP account. It names a beneficiary, and that takes precedence over my will. The third way assets pass on is through my last will and testament, my will. Well, if you think and reflect for a moment, it's possible that 90% of your assets are owned based on title and based on a beneficiary type of an arrangement. And what happens is we spend thousands of dollars on these legal fees, and very often we're putting together various LLC agreements or trusts, operating agreements, buy-sell agreements, and we're expecting the monies to flow to the will to be dispersed to who you want, when you want, in the manner that you want, as easy as I just spoke it. And frankly, it's not, and it's quite complicated. So by having the ownership arrangement be, for example, payable upon death, you're now creating a title and ownership aspect of that asset going to this individual. And when you think about the assets that you personally own, because I don't know really who's listening to this broadcast, you really do want to reflect and look at what assets do I own or what assets do we own, and then what assets are owned that have a beneficiary contractual arrangement. And you really want to see those updated beneficiary arrangements to make sure that they're correct, that they're still intact. I was with a client last week where we looked at an old 401k plan and we looked at some life insurance of his, and his ex-wife was the beneficiary on some of those assets. Needless to say, he was a little upset about that. Now, by the way, if you're a New York resident specifically, and there's other states that this is applicable for, you really need to own certain assets and have those assets go into a trust for a New York exemption to take place. And the New York state has an estate tax, ESTAT tax, that if you don't fund it properly, you lose it, which is different than a federal type of a credit where if I don't want to use all mine, I could, pass it on and use some of my spouse's. And we have that type of flexibility upon death. So I don't know what the estate tax the number is. Today, it's about $12 million. And I don't know what it's going to be in the future. So, what we want to look at is we want to look at your current tax laws. We want to look at the value. We want to look at a time of an estate. And how can we set up this estate plan? So, there's some key components to it, an estate plan, which I'm sure you've heard and I'm sure you've noted and hopefully have updated your own personal assets. Um, you have a will, you have a power of attorney, which is giving someone permission to represent your interests. And by the way, that can be today while I'm healthy, or that could be upon a doctor declaring me incompetent and not being able to make decisions on my behalf. A healthcare directive, or a living will, which is a pull the plug document. I was just completing one myself, and those questions of, do I want life support? Do I want a feeding tube? Are very serious questions to answer. And you want to give it thought, and you want to be able to communicate your wishes. Now, if you've got parents, aunts, uncles that are alive, you want to have these conversations with them. I wrote this book called Simon Says Love Your Legacy, a guide to financial education for you and your family. It highlights and talks about these kind of difficult conversations because, frankly, you never want to look at your loved one and say to them, what do you want me to do for you? If you have children over the age of 18, this is huge. Please listen. If you have a child over the age of 18, these children are now adults under the HIPAA regulation. The Health Insurance Portability Act declares an 18-year-old as an adult. If this adult doesn't give you, mom and dad, permission to represent them, a doctor legally cannot listen to you and or communicate to you. These are very, very important documents that you need to put in place. And this is the kind of CFO services, this is the dotting my I's and crossing my T's minutia that my team and I go into to protect you. When you have assets of a certain size, you can now set up various types of gifting strategies and trusts. Now, by the way, trusts are not just for the wealthy. And I bet if you think for a moment, every one of you actually has a trust. And a trust is, for example, your IRA. Money grows tax deferred. You may get a deduction or not. If you take the money before 59 and a half, there's a 10% penalty. These are the characteristics, these are the rules of that particular trust. And what trusts provide are asset protection strategies and also create preservation of capital. So I have a child. My son-in-law today likes me and loves me. And maybe in 5 years from now, my son-in-law or daughter-in-law may not like me anymore. And I do not want those assets to go to that son or daughter-in-law. By setting up proper assets, trusts, ownership, and the flow of how money is dispersed, I'm able to have assets go to my children for them to use and buy a house with, start a business, yet also protect it from a future son or daughter-in-law and other creditors and predators that are looking to, quote, maybe tap that asset that I worked real hard for and wanted to pass on to them. You need to update your wills and make sure they're properly structured. Very often I'll see a trustee or an executor, executrix, who is the administrator of the will. They're no longer in relationship, or maybe someone's passed away and or unable to represent and be the trusted advisor to help you to administer the will and or trust. Guardians, if you have children under the age of 18, this is crucial. Who's going to take care of your jewels? Who's going to take care of your diamonds? And as much as we want to procrastinate, we also want to be able to love them and take care of them with someone that's competent and able to make these very important decisions. Number one. Number two, if you have children that are maybe age 25 and under, and I just picked that age, are they really able to manage a couple $100,000, if not millions of dollars on their behalf? And you really want to look to an advisor or other family members to be a co-trustee in helping to manage the asset for these children. This is not a sexist comment. Um, and I'm going to say something because of 35 years of experience. I've had men say this to me and women say this to me. Guys, my experience is a lot of you are managing and responsible and taking care of the money. You may be buying stocks, you're buying investments, you're running the financial ship. Have you interviewed someone to take care of things if something happened to you? Have you told your spouse the importance of having her understand, be privy, be involved, have a relationship with an advisor so that when the baton gets passed from you to your spouse, it's going to be an easy financial transition. It's not going to be easy because I just lost my loved one. But like I said earlier when I started this, this is a conversation about love. This is a conversation about having a vision as to how I can do things to make it easier for my spouse and my loved ones upon my demise. And this is a very important question I say to people: that have you created a relationship with someone, and does your spouse realize the importance of either trusting someone or actually understanding so she could take the baton? Keeping this in mind, I hope you will not consider this information as food for thought, but rather fuel for action, because this is serious, important stuff. I spoke about the power of attorney. I spoke about the healthcare directive. I spoke about trusts. So I will close by saying, please take a look at the ownership of your assets. Take a look at how the flow, the disposition of assets would go upon your demise. And sit down with your current advisors, or feel free to reach out to me. And I'm not a lawyer. I'm a certified financial planner. I'm a fiduciary, and I'm able to offer education and make a difference, which is what I'm about. If you want any information, you can hit me on my website at saulsimon.com. Establish your goals, take an inventory, plan for tax efficiency because the laws are constantly changing. Have these important, loving conversations with your legacy so that they know what your wishes are, and review your documents often because things in life are often changing. I'm Saul Simon. Feel free to reach out. 1-888-SIMON says, thanks for the ear, and I hope there was value received today.
I have two questions for you.
Go ahead.
So the first is you talked about power of attorney, and my question is, so I've got a child that's 25, not married, and a daughter who's 28 who recently got married. Does marriage, so if we were powers of attorney for our children, for example, and one gets married, does that marriage supersede the power of attorney?
That's a great question, and I would want to ask an attorney that.
Okay.
And you should also check in with your daughter to see if she and her husband have created an agreement of some sort. My instinct is that her spouse is now responsible and helps to manage her affairs because they're married.
Great. And the second question is, in your opinion, is the discussion with a parent about power of attorney and planning a group discussion, or is that that individual's got to have that just by themselves, and they're professional.
I think I'm hearing the question. So, to have a conversation, it's about love. So if you could grab your siblings and come from a place of mom and dad. I attended a seminar this morning, and this guy brought something up that kind of hit home for me, because he said something like, I never want to be able to do something for you, but I don't know what the answer is. I'm asking you, tell me what it is you want. Tell me what it is you want me to do. I love you. I want to follow your instructions. Do you have these documents in place? Is it you or your older/younger brother, sister that's going to be making these decisions? The personal diamonds or jewelry or that beautiful painting or piece of art, where do you want that to go? How do you want that to go? Because you don't want anybody fighting. I mean, my goodness, I don't have to tell everyone in this call how often we hear people fighting over money, over stupid types of a cup. It could be a cup, as silly as it sounds. So what we try to do is love your legacy. It's about being able to just have things be easier for this transition. And in my opinion, you also want to say something like, I don't need your money. I'm not coming from wanting your money or taking your money. I want to give you the actions that you want.
Right.
And yeah, money is part of it. So I need to know who owns stuff and who's the beneficiary of stuff. And I use the terminology stuff because it's like stuff. It's all her stuff. It says his stuff.
Right.
You just want to follow their wishes. And that's love.
I want to just jump in and say that it can be a very difficult conversation. And depending on the relationship you have with your parents or your in-laws, as Saul said, or your siblings, the sooner you can start it, the better you are. My brother and I ran into that with my mother, who was left a widow and then had some dementia issues. And it became a really hostile environment because we needed to get power of attorney, and she was already not in a great place. And it was a horrible thing. We had to bring in psychiatrists to have her declared incapable of handling her things. So I'm just saying to everybody out there, if you're in a situation with elderly parents, try to have the conversation way sooner than later with your siblings. As Saul said, it makes a huge difference. And I wish I had known Saul a few years ago when we were going through this. It would have made life a lot simpler.
And that's how I started this conversation. This discussion it wasn't necessarily about the money, and it's about love. It's about being able to pass the baton to the next person without me being here, with some sense of comfort and competence and ease. Because the paperwork and the administrative aspect is overwhelming, and it's very upsetting to a lot of people that have to deal with this, as many of you probably have experienced.